Hello and welcome. I'm Robin Lipsky, and I have the honor of being the Executive Director for the Ninth Circuit's Historical Society, the NJCHS. Our mission is preservation of the vibrant legal history of the West and education about the importance of an independent judiciary. And tonight's program is such an excellent synthesis of all of our interests. We know you'll enjoy this program, and we hope to see you also at future events. The best way to find out about those is to get on our newsletter, and we'll put the link in the chat box later. And of course, we'd also love to have you as a member. In the interest of saving time to hear from our panel, I will give our moderator, Judge MARSHA BERZON, a much briefer introduction than she deserves. And then I will turn the program over to her to introduce our panel and to get us started. Judge MARSHA BERZON is a graduate of Radcliffe College and the Law School at the University of California at Berkeley, where she was article editor of the California Law Review. She served as a law clerk to Justice William Brennan Jr. of the United States Supreme Court and for Judge James Browning of the United States Court of Appeals for the Ninth Circuit. Before joining the United States Ninth Circuit Court of Appeals, Judge BERZON was an appellate and Supreme Court advocate at Altshuler, BERZON, Nussbaum, BERZON, and Rubin, a San Francisco law firm. She presented cases in most of the federal circuits and the appellate courts of California and several other states. She filed briefs in dozens of cases in the United States Supreme Court and appearing 4 times as an oral advocate before the court. Judge BERZON was an advocate in precedent-setting cases in the fields of labor and employment, environmental, women's law, and free speech. She was confirmed as a judge of the Ninth Circuit in March of 2000. She has written and taught extensively and has been the recipient of numerous well-deserved accolades. We are very excited to have her here with us this evening, and I will now invite Judge BERZON to take the helm of this program.
Thank you, Robin. I am, first of all, apologize for the fact that we were not able to do an in-court or in the courthouse event today and had to go all virtual at the last minute. So I hope that those of you who are planning to come in person were not disappointed. I think all the panelists were disappointed not to see each other. As you all know, in recent years, the Supreme Court has, under various rubrics, brought historical inquiry into the forefront in constitutional jurisprudence. The text, history, and tradition, or originalist approach, became determinative in Bruin under the Second Amendment most prominently, leading to intense into the regulation of firearms as far back as the 14th century. But a similar approach was also invoked in Dobbs, looking into the history of abortion regulation to determine the scope of the substantive due process guarantee in the 14th Amendment. In Students for Fair Admissions versus Harvard, the affirmative action case, in Justice Thomas's concurrence and Justice Breyer's dissent, in Moore versus Harper, addressing the independent state legislature theory in a redistricting case from state court, and in Gamble versus United States in determining whether the dual jurisdiction qualification on the constitutional ban on double jeopardy should be reconsidered, as well as other cases. In each instance, there was disagreement among the members of the court as to what history actually teaches about the issues at hand, and often dueling amicus briefs by historians as to the lessons of the past. I note in passing that I was a history major in college, though these many years ago, when history was the most popular college major at my university. That popularity has dipped to low single digits recently, with economics and computer science in the ascendance. Presumably, that is because history was seen as of little practical use in earning one's living. Perhaps the new ascendance of historians in the legal realm will change that perception. Whether that occurs or not, the ascendance of history has raised a number of questions concerning the intersection of law and the historian's craft, which is largely what we want to address today. We are not going to debate too much whether the Supreme Court turn is for the better, although we'll probably debate it some. Rather, our question is how that turn is likely to play out in the courts. There are various views represented on this incredibly stellar panel. All constitutional scholars, a law school dean and a former law school dean, and a future head of the London School of Economics, as well as perhaps the preeminent constitutional historian. We tried to interest other voices as well, but I think you will find a divergence of views among our panel sufficient to make the discussion lively. We're going to begin by asking each of the panelists to present a summary of their thoughts on the issues before us, and then I will try to foster the discussion by asking a series of questions. And if there is time at the end, we will entertain a few questions and answers. So there is a question and answer function on your screen, and if you have any questions as the discussion evolves, you can post them, and we will try to amalgamate some of them if there's time. First, before we proceed, let me introduce the panel briefly. Larry KRAMER has been president of the William and Flora Hewlett Foundation since 2012. Under his leadership, the foundation has maintained its commitment to areas of enduring concern while adapting its approaches and strategies to meet changing circumstances and seize new opportunities. He has at the same time been instrumental in launching new efforts to respond to pressing and timely problems, such as challenges relating to democracy and cybersecurity. Larry is about to become the president and vice chancellor of the London School of Economics. Before joining the Hewlett Foundation, Larry served from 2004 to 2012 as the Richard E. Lang Professor of Law and Dean at Stanford Law School. His teaching and scholarly interests include American legal history, constitutional law, federalism, separation of powers, the federal courts, conflict of laws, and civil procedure. At the start of his career, Larry served as a law clerk to the U.S. Court of Appeals, Judge Henry J. Friendly of the Second Circuit, and as I did, to the United States Supreme Court Justice William J. Brennan. Following his clerkships, he served as a professor of law at the University of Chicago, University of Michigan, and New York University Law School. He is Dean Emeritus at Stanford Law School, a fellow of the American Academy of Arts and Sciences, and a member of the American Philosophical Society. He is the author of numerous articles and books, including The People Themselves, Popular Constitutionalism and Judicial Review. I'm doing these introductions in the order in which people will speak. Jack RAKOVE is the William Robertson Co-Professor of History and American Studies and Professor of Political Science and by courtesy law at Stanford, where he's taught since 1980. His principal areas of research include the origins of the American Revolution and Constitution, the political practice and theory of James Madison, and the role of historical knowledge in constitutional litigation, today's subject. He is the author of 6 books, including Original Meanings, Politics and Ideas in the Making of the Constitution, which won the Pulitzer Prize in History, and Revolutionaries, A New History of the Invention of America, which was a finalist for the George Washington Prize, and he is also the editor of 7 other books, including The Unfinished Election of 2000. He's a member of the American Academy of Sciences, the American Philosophical Society, and a past president of the Society for the History of the Early American Republic. And finally, ERWIN, CHEMERINSKY, who was in an Uber until about 1 minute before he came on the screen, coming from San Francisco, where he did another panel earlier today. ERWIN became the 13th dean of the Berkeley Law School on July 1st, 2017, when he joined the faculty as the Jesse H. Chopra Distinguished Professor of Law. Before assuming this position, he was from 2008 to 2017 the founding dean and distinguished professor of law. So he started the law school at Irvine. He was the Raymond Pike Professor of First Amendment Law at the University of California, Irvine School of Law, with a joint appointment in political science. Before that, he taught at Duke University and the University of Southern California Law School. He teaches constitutional law, First Amendment law, federal courts, criminal procedure, and appellate litigation. He is the author of 10 books, it may be 11 by now, including The Case Against the Supreme Court, published by Viking in 2014, and 2 books published in 2017, Closing the Courthouse Doors, How Your Constitutional Rights Became Unenforceable, and Free Speech on Campus. He's the author of more than 200 large articles, which is incredible. I always say ERWIN doesn't sleep. And he writes a weekly column for the Sacramento Bee, monthly columns for the ABA Journal and the Daily Journal, and frequent op-eds in newspapers across the country. He frequently argues appellate cases, including many in the United States Supreme Court. In 2016, he became a fellow at the American Academy of Arts and Sciences. In January 2017, National Jurist magazine named Dean Chemerinsky as the most influential person in legal education in the United States. So, as you can see, we have a rather remarkable group of people here today, and I hope you will very much be illuminated by what they have to say. We're going to start with Larry, then we're going to go to Jack, and then we're going to go to ERWIN, mainly because we thought ERWIN would be rather exhausted after his treacherous trip across the Bay Bridge. So let's start with Larry.
Thank you. And it's a pleasure to be here. So I think I just want to make a couple of introductory points. One, to clarify something that even in our own conversations emerged as a confusion that people often make, which is the difference between the use of history in constitutional interpretation and theory and originalism. So I don't know anybody who does constitutional interpretation who does not think history is relevant and doesn't actually use it as part of the work that they do. The distinctive thing about originalism is the idea that, which is really a legal theory idea, right? That at the moment of enactment, the meaning of a text is fixed. And so you have to use the history to understand what that meaning was and that it never changes. The only way to change it is through a similar kind of process to the process that enacted it. So that is one way to use history, but it is not as though any use of history makes one an originalist, or that anyone who is not an originalist doesn't use history. So in my own understanding, for instance, and I'll just touch on this quickly, I think the nature of law is inherently a kind of customary law. That is to say, law inevitably evolves over time because you apply it in circumstances, the circumstances are changing, the understanding of the people who are called upon to interpret it later, and that's true whether it's statutory, constitution, common law, is necessarily changing. So it's a kind of epistemic fact that law evolves and changes over time. The shape of problems change, and then so your understanding of what that law means in a changed context changes, and so on. So that is literally inherently the nature of law. And the point about constitutional law is it's just a form of customary law that is essentially refracted through the text, so that evolving understandings of the text over time are the way in which we express the evolution of constitutional law. And as I say, I think that's unavoidable, and it gives you part of the reason why you need to think about history, because if you want to do that well, you need to understand where this started and how it has evolved in order to actually understand the nature of the law today and the way it has framed problems for you today and what has been answered and what remains open. The other point that I think I want to make is it's not just that that's kind of epistemically necessary, that it's inherent in the nature of law, but that it's also the right way to think about it, that to not think about it that way is pragmatically really kind of foolish. And let me make the point with a simple analogy. Think of the government like a boat, a ship, a state, if you will, and the Constitution is the blueprint that was used to build that boat. So the founders of our Constitution created the blueprint, they built the boat, and then they launched it to sea. And once they were out at sea, they began encountering problems that they hadn't anticipated. Some of them were because of flaws in the boat's design, right? They didn't actually know everything. Some parts didn't work as they had expected it to. Some of the parts were actually, it turned out to be kind of poorly fitted for purpose. And other flaws emerged because the designers had misunderstood sort of what the weather was going to be like. And they didn't know enough about what it was like to be at sea. They had never actually done that before, which was true. And so they encountered, sort of storms that were rougher than expected and currents that pushed the boats in ways they hadn't anticipated. And since they're already at sea, the one option they don't have is to kind of take the boat apart and rebuild it from scratch. So they're making repairs on the fly, doing their best to fix the problems as they go along. And sometimes the repairs that solve an immediate problem then give rise to still new and other problems, which then requires still more repairs on the fly, and so on. And, the ocean itself changes, right? So in our world, the climate change happens, the weather is rougher, the currents are different, the demands of the sea become new and different, all of which then leads to still more changes to deal with the conditions that the creators of the boat could never have imagined, and that even as modified, the boat wasn't designed for. So now you've been out there sailing for 2 centuries, the boat's still out there, but it's a radically different from the boat that was first launched, right? The kitchen that used to be on the starboard side is now on the port side. It's all new equipment. The stairways have been replaced by elevators. What used to be wood is now metal. Sails have been replaced by these big combustion engines. We used to have a small crew. It's now huge and it's very diverse, and so on and so on. So say what you will about the process that led to the new boat. One thing is obvious. If a new problem emerges, it would be inane to try to repair it by following the original blueprint. So the analogy there, I think, is pretty obvious, right? Like the boat, our government is a complex system of interrelated parts. Like the boat, it's been constantly changing for more than 2 centuries to the point where it doesn't actually resemble the original plan hardly at all. Like the boat, the requirements of and for government are wholly different in a society and global context that's radically changed in ways that absolutely matter for what it takes to govern effectively. So when you encounter problems, you need to address them within the system that's evolved. And that's, as I say, inherently the nature of law and how it changes over time. So any theory of interpretation that ignores that, honestly, is just plain dumb in my view. The Constitution is inherently, inevitably that kind of customary law. It doesn't follow that there's no law, and it certainly doesn't follow that judges are free to do what they want, and it definitely doesn't follow that the original design is irrelevant. It still matters to understand the critical principles we're trying to keep in mind, right? And the subsequent evolution, though, matters too, so we can understand how those principles have been applied in changing circumstances, understand the best choices to solve the problems we have today. So that, to me, is the way in which to think about the role of history in interpretation.
Okay. I think it's my turn now. Larry having finished up.
Rakove, I'm sorry. I have to unmute myself. So go ahead.
Okay. So I think there are 3 main points I want to make by way of introduction. The first is derived mostly from my own experience as both an expert witness, actually 4 decades ago in Oneida Indian land litigation in upstate New York. And then I think on the basis of having been the main author of 5 amicus curiae briefs for the Supreme Court. So when I think about the role of historians in legal matters, whether it involves being an expert witness in litigation on the one hand, or writing amicus curiae briefs on the other, my main position is that our ambition professionally should always be to act as the best historians we can possibly be. I know when I worked on the Oneida stuff, it was quite exciting, and it got kind of caught up in the combative nature of litigation. And there's our team, there's the other team. It's an adversarial proceeding. One side's going to win, the other side hopefully is going to lose, and so on and so on. But the more I did it, the more I realized that my obligation was not to think as the advocates would. It really was to come up with the fullest account of the historical questions that were involved in the litigation. And that had to do with the fact that I came to understand how the discovery process worked. And I realized that in the end, all the evidence is going to be available on both sides of, both sides of the courtroom or whatever. And that I would act most responsibly simply by trying to be the best historian I could be. I think the same thing is true when you write an amicus curiae brief. You're kind of limited somewhat, actually a lot, in terms of the amount of space you have. And so there's always kind of the pressure of economizing and tightening your prose and getting the main points out. But again, you need to take account of the whole array of arguments that exist on the question. And so I think the best service you can do within the constraints of time and space is first and foremost to survey the sources. So there's a sense in which I think historians we have our own norms of how we should conduct our research and our writing, and we'll make the best contribution we can to the legal project when we honor those norms, even though we recognize that lawyers will ask questions that historians ordinarily will not think are worth asking or answering. Litigation generates its own problems, and you have to take those problems seriously, even when those problems don't seem to be the best kinds of questions we as scholars would ask about the past. So that's point number one. My second point has to do with the question of originalism, which is something I actually started thinking about not 40 years ago, but 50 years ago. When I was a graduate student, I started thinking about the issues of, the War Powers Resolution and the impeachment of Richard Nixon. And those were questions which inevitably raised questions. Those are problems which raised questions about what had the framers intended. What was the understanding of those issues at play in the 18th century. And it occurred to me, and I still believe this very much now, almost as an article of faith, that all questions about the original meaning of the Constitution are inherently historical in nature. Indeed, I could not have understood how any other method of asking what did a document originally mean could possibly exist if it didn't operate within primarily historical parameters. So when I wrote the book that became Original Meanings, my Pulitzer Prize winner that came out in 1996, in effect, I had my own method, my own model, or I was trying to work out what would a historically responsible method of saying what did a clause of the Constitution originally mean? What would it look like? And I've tried to follow that method when I write amicus curiae briefs, and I think I can't do it perfectly, but I've tried to do it as consistently as I could. But the flip side of this, and I think what makes originalism such a problematic exercise today, is that what I assumed almost as a matter of common sense. Of course, if you want to ask what the Constitution really meant, you would necessarily be engaged in a primarily historical examination. That's not the case anymore. If you get into the technical literature of originalism, which has become a vast and rather repetitive academic field, what you'll discover is there's a kind of turn away from history, at least in the sense that historians do it, and it's become very much a linguistic, or we could say a textualist endeavor. And I could give different examples of this. I mean, the last brief I was the main author of was a brief in Moore versus Harper, the North Carolina reapportionment case, which invoked the so-called independent state legislature theory. To me, the most remarkable thing about the argumentation was that hardly anyone addressed the actual debates in the Constitutional Convention, which underlay the election clause, or Article 1, Section 4 of the Constitution. Chief Justice Roberts mentioned it, but almost in passing, just to illustrate a fairly minor point. Whereas if you took that debate seriously, the whole punitive basis for the so-called independent state legislature theory would basically dissolve. It would seem to be almost nonsensical. So I do think that there is, that we are at a moment in the jurisprudence when originalism, which I think, and I still think correctly, and I think it's consistent with what Larry was saying, would have to be necessarily, at least to some extent, a historical endeavor. That's not true jurisprudentially. At least it's become more problematic jurisprudentially, and therefore operationally. And then the third point I want to make is, the basic framework here for the court, particularly coming out of the Bruin decision, and I suppose to some extent the Dobbs decision, is we want to look at history, tradition, and text. And I think the most anomalous facet of that trinity, that trilogy, however we want to characterize it, is the notion of tradition. I don't know what the court means by tradition. When I read the Bruin case, which is the New York case based on the carriage of firearms in public places and private places and so on, the appeal to tradition seems to me to be kind of a vacuous concept. I think the court's notion of tradition is it's part of our tradition if it's consistent with the decision in DC versus Heller. If it doesn't score at DC versus Heller, it's very problematic as a tradition. If you're a working historian, you'd say to a certain extent, every evidence of a past practice, if you can document it, demonstrate it was actually done this way, illustrates some kind of a tradition was at play there. And the great problem here is, I think, in terms of spelling out tradition, the court wants to argue, and again, the Bruin case is, the New York case is first and foremost in mind. The court says you want to reason by analogy. If you can compare a current regulation with some past practice or some past regulation, that will make the legal analysis work. And here I just want to say two things. One, I think Larry just illustrated this point perfectly. It's first thing I want to say is historians don't reason by analogy. In fact, I was taught as a graduate student that the best way for historians to think is to try to distinguish the past from the present. And that's the whole point of studying the past, is precisely because it's different. So to draw analogies to us seems to me to be a very problematic endeavor, but it comes naturally to lawyers. And Larry, my former colleague and close friend, just illustrated this brilliantly with his nautical metaphor for the Constitution. Larry naturally, without I think fully realizing, being fully conscious of what he's doing, just naturally lapsed into an analogical mode of reasoning in a way that a historian would never do. So those are my three main points, and I think I hope I put enough ideas out there that we can discuss further.
And Dean Chemerinsky.
Thank you. It's really an honor and a pleasure to be part of this panel. In 1987, Robert Bork was rejected for a confirmation on the Supreme Court because of originalist views. He was impeccably qualified. He had been a professor at Yale Law School, Solicitor General of the United States, was a judge on the DC Circuit. But he was rejected because his originalist views would have meant no protection of the right to privacy under the Constitution, no protection for women from discrimination, a First Amendment that was limited entirely to political speech. Now we have three justices who are self-avowed originalists, Justices Thomas, Gorsuch, and Barrett, and three other justices who often write in originalist terms or join their originalist opinions. If I were to make the case against originalism, I would start with Brown versus Board of Education, Loving versus Virginia, Griswold versus Connecticut, Obergefell versus Hodges, and protecting women from discrimination, gays and lesbians from discrimination under equal protection. None of those could be justified from an originalist perspective. After all, in terms of Brown, the same Congress that passed the 14th Amendment also voted to segregate the District of Columbia public schools. There's no indication that they meant to eliminate segregation. In terms of Loving versus Virginia, most states had laws prohibiting interracial marriage. California did until 1948. There were still 16 states that had laws prohibiting interracial marriage in 1967 when Loving was decided. Griswold versus Connecticut, impossible to justify a right to purchase and use contraceptives if we're truly going to follow framers' intent. That's why Justice Thomas, in his concurring opinion job, said, now that we've overruled Roe, we should also overrule Griswold. At the same time, he said, overrule Obergefell versus Hodges, the 2015 decision that said that states can't prohibit same-sex marriage. And Justice Scalia had said, and on many occasions said, that there's no protection for women from discrimination under equal protection because that wasn't the framers' intent. And of course, by the same measure, there'd be no protection based on sexual orientation or gender identity. I think it makes no sense to be bound in 2023 by what people thought in 1787 or even 1868 for a vastly different world. Often the question is absurd. The Supreme Court, with regard to the First Amendment, decided in June of 2022 that a public school teacher had the First Amendment right to pray on the field after football games. Justice Gorsuch, in explaining what violated the Establishment Clause, said, we have to do it by looking at what the founders' views were in 1791. Well, what did the framers of the First Amendment think about a high school football coach going on the field and praying after games? Just to ask the question is to show its absurdity. Or think of some of the First Amendment cases before the Supreme Court this term. There are two important cases as whether states can prohibit content moderation over the internet and social media. There's simply no analogy that one could find to the internet or social media. Or think about the Second Amendment case. United States versus Rahimi, they'll be argued next week on November 7th. It's a federal law that prohibits those under restraining order in domestic violence case from having a firearm. The Fifth Circuit said there weren't such laws in 1791, so this is unconstitutional. But restraining orders in domestic violence cases didn't exist in 71. There was no protection for married women as against their husbands. Or think about it in terms of the Fourth Amendment, the Supreme Court's decision from 2018 in Carpenter versus United States, where the court said that it's a search within the meaning of the Fourth Amendment for the police to acquire a large amount of cellular location information about a person without a warrant. There was no analogy to acquiring cellular location information in 1791. The primary argument that is advanced for originalism is that it provides a constraint on judges and justices. I think that's just wrong. In part, it's wrong because history is inconclusive. As Justice Breyer pointed out in his dissent in Bruin, quoting the late Judge Pat Wald, the historical analysis done is often like when people go to a cocktail party and look for their friends. Lawyers, judges, justices go through the historical record and pick the examples that support their side. Rarely is the historical record clear, and rarely is it so unanimous you can say, this was the original meaning. But also, I think that even when there might be clarity in historic record, the originalist justices abandon originalism when it doesn't get to the conservative results they want. Example, think of Citizens United versus Federal Election Commission in 2010, where the Supreme Court said that corporations have the right to spend unlimited amounts of money in election campaigns to get candidates elected or defeated. You're not going to find anything from 1791 but campaign spending in corporations that's at all relevant to justify the court's decision in Citizens United. Or Shelby County versus Holder in 2013, where the Supreme Court found that the preclearance requirements of the Voting Rights Act were unconstitutional. The court said it violated a principle of equal state sovereignty, that Congress had treated all states the same. That's nowhere in the Constitution. In fact, the Congress that voted for the 14th Amendment also passed the Reconstruction Act to create military rule over the South. Or think of the affirmative action case, the Students for Fair Admission versus President Follows of Harvard College. Is the dissenting justice point out there's overwhelming evidence that the framers of the 14th Amendment also approved race-conscious programs like the Freedmen's Bureau that today would be thought of as affirmative action. Justice Scalia, when he's alive, was fond of saying, I have a theory and they don't. I wrote a book that came out a year ago about originalism, and I titled it Worse Than Nothing, The Dangerous Fallacy of Originalism. And it was a direct response to Justice Scalia's claim. Throughout American history, justices and judges have looked at many sources in deciding what conclusion to come to. Obviously, they always start with the text. The reality is the text rarely provides answers for the constitutional questions that go before the Supreme Court. They look to the extent they can find it, at the original meaning to framers' intent. Not that it's determinative, but as Larry said, just as it's relevant. Look to the structure of the Constitution. Look to precedent. Look to history and tradition. Look to modern social needs. All of these have always been the source for constitutional interpretation, and they should continue to be. They don't lead to determinate results, but there is no way to come to determinate results in constitutional law.
Thank you all. I had said we weren't going to debate originalism, but we are, or we did. As I said earlier, we had tried to have a voice to the contrary, but no one was available. So I would ask these three professors who are used to taking the contrary of their own position, what are the best arguments in their view favoring what I prefer to call the text history and tradition approach, rather than using the buzzword originalism, which tends to get people off on their own high horse. So if you were to, and I did warn that I was going to ask this question, so the question is, what are the best arguments essentially to the contrary of what you just said, if you're willing to do that? So Jack, do you want to start?
Well, I am an originalist of sorts. That's to say, under the suppositions, the arguments that, as I said, I started thinking about it a long time ago, just because I thought this was an interesting question historically. So I'm an originalist to the extent that it's very hard for me to understand how you could come up with a comprehensive, intelligent interpretation of the meaning of a clause if you could not explain its origins. And doing the kind of work that one often does, I think, in some kind of statutory construction, where legislative history is relevant. I mean, I disagree actually with something that ERWIN just said. I don't think history is inconclusive. I think when you know the sources and you immerse yourself in them, you try to reconstruct the debates that and the decisions that emerge from those sources, you can draw conclusions with, the certain, you have to suspend some measure of critical distance. So it seems to me that I will defend originalism to the extent of saying that any attempt to make sense of disputed clause of the Constitution should have as one of its core elements some understanding of how and why that clause made its way into the Constitution. But that proposition is very different from the premise that Larry laid out earlier, that the theory, the underlying normative theory of originalism says that the meaning of the text was fixed at the moment of its adoption. There are lots of ways that one can unpack, criticize, and effectively debunk that supposition. So I think in one sense the role of history is to say, I think I'm correct there, that if you really want to understand what a clause of the Constitution meant, at least at its inception, to reconstruct the history of its adoption is an essential exercise. But that leaves open the question of what should be its relevance today. And of course, in some ways, the Second Amendment is the ideal case to try this about. I mean, the more you work on the differences between firearms in the late 18th century and firearms as they operate today, I mean, the more counterintuitive it is to believe that any understanding of the Second Amendment should be binding today, because the technology we're dealing with. I mean, here Larry's maritime analogy comes back into play. And as I mentioned earlier, I mean, I don't know if Erwin knows his historian colleague Brian DeLay, who has the same background that I do, but DeLay is an excellent essay out there, showing just all the enormous differences between firearms use in the late 18th century and firearms use today. So, I could go on here. I could also say that originalism is fundamentally anti-democratic in lots and lots of ways. But I'll defend it so far as saying the original, to understand a clause comprehensively, you have to understand its origins. And when you do that, contrary to what Erwin was saying, some arguments make a lot more sense than others. I can make a pretty convincing argument that the Second Amendment was about the militia, but it wasn't about a personal right of self-defense.
Let me just jump in. I will actually defend originalism. I think it's easily defensible, even though I don't happen. So as I say, let's keep our language straight. Using history, trying to understand the original, that is not originalism, right? The nature of originalism, what it means, that what sets it apart is this notion of a meaning that was fixed at a point in time. Okay, so then what Jack's talking about just isn't originalism, it's just using history, and one could talk about whether and why. And Erwin's point about inconclusivity is as much about the application of something then to today, even if the historical sources are perfectly clear so that we can understand what it meant then. That's not what originalists are doing with it necessarily. And so I think there's a lot to be said to that. But here would be the defense of originalism, which is, it is the nature of positivism. So imagine a statute was passed yesterday, okay? And we had to figure out its application to a case today. How would we do that? So we would look at the text, we would look at we would try and understand sort of what the law was meant to do and how it applies to this case. Now, there will be indeterminate cases, even with the statute that was passed yesterday. And the fact that we might then therefore disagree about its application, nobody thinks that makes it not law. We have a set of interpretive norms that we use to come to a conclusion about how to apply that statute that was enacted yesterday today. And all an originalist is saying is, and the fact that it's like 3 weeks ago, 3 years ago, 30 years ago, or 200 years ago doesn't change that. It's not anti-democratic because there's a process, if you don't like the statute that was enacted, for getting it changed. So too with the Constitution. So you have to go through that process to change it. There's nothing, I mean, that's a perfectly, coherent legal theory, right? It's like, that's the nature of law. Someone gets the power in a democratic society to make a law that's going to bind other people. They exercise that power through a process. Once they've done that, the only way then to change it or undo it is through a similar process of changing the law by somebody who has that authority. And that's fundamentally what the theory of originalism is. I think for some of the reasons we've talked about it, there are lots of problems, but it's neither anti-democratic. It has a way to deal with the problem of ambiguity, and it's not incoherent to a lawyer.
Erwin, do you want to say anything about that?
Let me say that,
Yes.
and then I do want to respond to Jack, because there is significant disagreement here. I think in terms of defending originalism, one is an argument about the nature of a legal document, that when we're interpreting a contract or a statute or the Constitution, we should always be looking to determine what was the original meaning. It is what Larry said here, a very positive approach. And second, what originalists frequently say is they offer a constraint on justices in judging that's desirable. I do believe that history is often inconclusive. In terms of the Constitution, So many people were involved in drafting it. It's hard to say there was an intent. I like when I teach constitutional law to show all the instances where Hamilton and Madison disagreed. Hamilton believed that there's inherent presidential power. Madison rejected that. Hamilton believed that Congress could spend for any purpose. Madison rejected that. I don't know that we can say that one of them is the authoritative meaning of the Constitution. If we're going to look at practices that existed, there were so many different practices going on. You've got to decide which ones are relevant. So Justice Breyer in his dissent in Bruin says, look at all of the restrictions that existed with regard to keeping people from having guns in public, having licensing systems and the like. And Justice Thomas says, well, some of those were too early, some of those were too late, some of it is just Texas. But of course, you have to make the choice about which ones are you going to look at. But I think the most important reason why history is inconclusive is so much comes down to the level of abstraction with which you interpret a constitutional provision. Let's take the example of equal protection. One way of viewing equal protection is it's really meant to be about stopping race discrimination. That's what the court said in the slaughterhouse cases. You could say, no, equal protection is about protecting groups that were historically disadvantaged, broader. You could say that equal protection is about protecting all people from discrimination. And I could come up with many different answers. I don't think that there is any right way to choose the level of abstraction. And the choice of the level of abstraction determines the outcome. We see this with regard to Rahimi. When you look at history, do you focus on in 1791, were there laws that kept people, the restraining orders in domestic violence cases having guns? What do you say in 1791 were the laws that kept dangerous people from having guns? I can't help but respond, Jack, to your point by relating a personal experience. From 1997 to 1999, I chaired a commission in Los Angeles to write a new city charter. Ultimately, the voters adopted it. Almost immediately, issues began to arise as to its meaning. And what we discovered is rarely had we thought about those questions. When we did, we had different recollections of what we intended. And I found that each side would call and say, what did your commission mean with regard to this? And if they liked my answer, they say, would you write a declaration? And if they didn't, they'd keep calling commissioners till they got someone to say that. We had years initially after its adoption, we're all still alive. There was no original intent that we could find for most of the provisions there. And that's even more so when you look at a document written in 1787.
So again, Erwin, I'm just gonna, sorry, I'll jump in, Jack, you may want to respond, but original intent is not what anyone is talking about. And everything you said would be equally true as it was in your example for a statute that was enacted yesterday. So the problem of ambiguity in all those ways is something the law grapples with all the time. And we have a set of interpretive norms that we use to reduce uncertainty to a case. And all an originalist is saying is, yeah, and that's what you should do here. You should use the norms that would have existed at the time, which is why it's not original intent, and that's how you got to the public meaning thing. Now, I think there is a totally legitimate criticism of originalists, which is, but they don't actually do that, right? They use dictionaries, and nobody used dictionaries at the time. There's a million criticisms about how it's applied, and I think those are all fair, but the theory itself isn't actually punctured by any of those problems because those existed then for ambiguity in cases that they also hadn't anticipated that they had to solve, and we're just talking about new ones. And it's just a question of which interpretive norm should use. And all they're saying is, since the meaning was fixed at the time, it should carry with it the interpretive norms that went for reducing ambiguity to solutions in cases. And as I say, I don't think that's incoherent. I think it has a million other problems pragmatically and epistemically over time. But
yeah, I guess I would just intervene to, mostly in response to Erwin, to qualify my remarks in this way. This is what I said at the very beginning, and I don't know if you, Erwin, if you heard my opening remarks or not, but you did. Okay, so being the best historian you can be in this realm of scholarship means, I think, reconstructing what the debates were about. And in those debates, you can, and I've spent a lot of time working on Madison and Hamilton on the executive power and the letters of Pacificus and Helvidius. I once proposed to John Yoo that maybe we should redo them from a modern, I'm a Madisonian, he's a Hamiltonian. Maybe we could try to rewrite that debate from 1793 in our own terms, and so on. So I think de minimis, the historian's responsibility, opportunity, duty is to reconstruct the debate itself. And that itself, it seems to me, is a way I'm not going to say it's going to, I don't think it's going to make history inconclusive. It's going to allow you to understand what was in dispute. And then I would extend that. And I made this point briefly, but to bring the Second Amendment back here, there are a handful of references, but just a handful in the elaborately documented record, 35 volumes and counting, of the debates over the ratification of the Constitution. All those relating to the militia clauses of Article 1. There were a handful of references, but just a handful, that might imply, if they're broadly extended, that maybe this had something to do with an individual right of self-defense. But the overwhelming majority of references says all the debate was entirely about the status, the institutional status of the militia under Article 1 of the Constitution, where Congress has the authority to oversee the states, and if it wants to lay down its own rules for how they're to be organized, armed, and disciplined. If you establish that point, then the whole line that comes from Heller and is renewed in Bruin, that the fundamental purpose of the Second Amendment was to protect an individual right of self-defense, is disposed as the nonsense it really is. So I think in reconstructing the debate, is it fully conclusive? Can you identify every point? No, probably not. But I think you can recreate the framework in a way that some realm of interpretations become much more likely and probable, and others become highly unlikely and highly improbable. And I actually think the Second Amendment, for reasons that are ultimately tragic, in many ways, has become the most important test case of what originalism really means operationally.
I fear that we're begging the question. The crucial normative question is, how much should history matter in interpreting the Constitution today? And I think my answer to that is, it's relevant, but it's not as important as other things are. It's not as important as the modern social needs that should influence interpreting the Constitution. It's not as important as precedent should be in interpreting the Constitution. Not as important as tradition should be in interpreting the Constitution. Whereas those who are originalists would say that the only thing that matters is what was the original meaning. And that's fundamentally where I disagree normatively. And I don't think there's a sufficient case for originalism in that sense. And as I said, I think there's a strong normative case against it, because we shouldn't accept, from a normative perspective, a theory of constitutional interpretation that makes Brown, Loving, Obergefell, and cases like that illegitimate.
So, to descend from the level of high theory to practicalities, the fact is that we do have a court that is telling us that history is, if not, it's close to all important. And the question that I want to raise, because I assume most of the audience are practicing lawyers, is what practical problems does the historical approach pose for lawyers and judges? One of the documents that we posted on the website for this panel was an opinion by Judge Reeves in Mississippi, in which he said, I'm a district court, I'm not a historian, how am I supposed to know what the precepts were in 1791 or in 1868 or after the Civil War, about whether felons should be barred from having firearms. So I would like to appoint a historian to help me and ask the parties what they thought of that idea, and they both rejected it, so he didn't do it. So how are district courts and courts of appeals to gather comprehensive information? The Supreme Court is a different operation, because by the time a case gets to the Supreme Court, there's sort of an infinite amount of resources, and the eyes of the nation are upon it, and people will come out of the woodwork to tell the Supreme Court more than they want to know, but that isn't necessarily true in district courts and courts of appeals. So what is the likely role of historians in the so-called lower courts, a term I don't like, as witnesses and make these special masters, tutors in patent cases? Sometimes judges appoint a so-called tutor or tutorial about the technicalities of patent law, and then who chooses which historians. Does anybody have any thoughts about how this actually operates on the ground?
So, I would start with Jack's point, which is what the judges are doing, what lawyers are doing, is not what historians do. So the solution is not to bring in historians as special masters. They actually can't answer the question the way the court wants it answered. And in fact, the only way they can do that is kind of by betraying their discipline to a certain extent. And if they stay true to the discipline, it's not helping. But you could, again, ask the same question with respect, say ERWIN says, and I agree with him, like policy implications matter. Well, how do lawyers deal with that? You know, they're also not social scientists, and we don't say, bring economists in to testify. What we do is you as a lawyer, and you're an advocate for a side. So you find the evidence that supports your side and you present it. And that would be equally true for social science and policy consequences as it is for history, and recognize that this is a forensic construction that courts are making. It just isn't history. So all those questions about what level of generality should we be at? Well, I'm going to pick the one that works for my side. The people on the other side are going to pick the one that works for their side, and the judge is going to just, or the judge in these cases, is going to decide which one feels more persuasive. And we will go through that process for these kinds of questions as we did for everything else. It would be a mistake to think that, no, that because it's historically, it has some objective process that reaches an outcome. That may be true for historians in the way they do history to some extent, but they're not answering the same kinds of questions. So, you know, it's like, let's just fold it into the practice of lawyering, as we have so many other things since the legal realists emerged in the 1920s.
But Larry, I mean, that position seems to me to miss in, you know, I don't mean this in too personal way, but it seems to me you're not taking seriously the ostensible challenge or whatever that the court laid down, I think, first and foremost in Bruin, but also I think maybe to some extent in Dobbs and the other case. That's Breyer's dissent in Bruin, I think, is great. What was he doing? I mean, the whole point of Bruin, as I understand it, was that in the second realm of the Second Amendment, post-Heller jurisprudence had worked out a mechanism for considering additional claims. So, first, as I understand it, this piece of mine that just went up in the Wall Street Journal for the weekend, I try to discuss this briefly. First you ask whether the activity in question, how well it's covered by the existing doctrine as a Heller, and then if it isn't, then you go about you employ what strikes me as being just as a citizen, the perfectly sensible mechanism of a balancing test. But and that what are the collective interests? I mean, how strong a right do you want to recognize? What effects, what consequences will follow? That's a classic kind of balancing test. But it seems to me is you guys can read this much more intelligently than I can. But even so, it seems to me that what Thomas was doing, in his opinion, was saying we're throwing out the balancing test notion, and now we're going to rely on history, tradition, and text. Of course, the text is ambiguous, but it seems to me the reliance on history.
All I'm saying is the practical question of what a lawyer should do is the same thing a lawyer should do with any other kind of argument. The legal system absorbs all sorts of, so you find the best arguments here within history that support the case you want to make. You make yours, they make theirs. The judge has to resolve it. This will eventually force I believe, it will eventually force the court to recognize the incoherence of what it's trying to do and force it to back off, as has happened with other similar kinds of things. Or they will reshape and narrow it and make it workable. That's the way the legal process works. But from the practical perspective of a lawyer, I don't think it's a huge challenge. And honestly, from the practical perspective of a judge, I don't think it is either. It's like, here are the materials. I have to make the best sense I can out of them and try and justify the opinion to the result that I think is right in the best way that I can. And this will be the process that will unfold across many cases.
Yeah, but Larry, I have all these friends, and Brian DeLay is one of them who are out there. They're being asked by judges and litigants alike to go out and do a lot of historical research under what kinds of regulations were practiced. Was there legislation? What was done judicially? Historians would argue actually a lot of this stuff is being done by justices of the peace, and you can only discover at the community level that relates to the Rahimi case for next week. So I mean, I understand everything you're saying, but it seems to me the court has laid out a new challenge, and judges and lawyers, as they do what they do, are struggling to make sense of what they're going to do. No. Yeah.
I want to agree with Larry here that I think that lawyers are doing what they've always done. It's just an additional type of argument, an additional type of research. Let me take it out of the Second Amendment here. And there were a couple of Supreme Court cases a few years ago about the Fourth Amendment. One was Lang versus California, of whether police can enter somebody's home when they're in hot pursuit if it's a misdemeanor. Justice Kagan wrote the opinion, and she focused on the law around 1791 in answering this question. Same term, the court decided Torres versus Madrid in terms of police are chasing somebody for a long period of time, is there still a seizure? And Chief Justice Roberts wrote the opinion going back to the laws that existed in 1791. So it's not just in the Second Amendment that this comes up. It's not just in the high-profile cases. And what lawyers have to do then is get their copies of Blackstone or whatever it is that would reflect the contemporary law and make the best arguments they can. And the judges have to rely on that or do their own research about it. But I don't think it is kind of different than other kinds of research.
And we've seen other examples of it that you can think, like when I clerked, we had a bunch of cases, big antitrust cases that required understanding how the economics of international trade and mass production in ways that were well beyond anything any of us knew. Climate litigation today requires judges to get some kind of basic understanding of climate science, which is actually pretty complicated. And in all of them, so that's what Erwin and I think about saying. It's not significantly different in the economics context. It eventually forced the court actually to change the way it did this, because they eventually came to realize that it was actually impossible for judges to marshal the kind of evidence and make those kinds of conclusions. And I think they will find I think Rahimi is going to be a really good case for forcing them to recognize, well, this is insane, we can't do this. But that's how law works, and that's okay, right? And our arguments about why it's intellectually incoherent and theoretically incoherent are part of that process.
So how does, here's another thing that's been troubling me. How does the historical approach to legal decision-making cope with the stare decisis principle? So I was imagining, to use a hypothetical, what if a new diary of the 1787 Constitutional Convention turned up? Do you reconsider all the precedents that rested on the relative paucity of such information until now? And what do you do with, and this has come up a couple times recently, actually, because with regard to the double jeopardy case, for example, the court said that there was one of the cases that was being relied upon wasn't actually a reported case, and then somebody went and found the reported case. So what do you do then? Do you start over again? And similarly, as you all noted, there has been a lot of post Heller writings by historians debunking the history that was used in the Heller opinion. Is that a reason to redo the opinion? Essentially, I mean, Dobbs kind of did that in the other direction. No, was it Dobbs? Yes, I guess in critiquing Roe versus Wade, partly on having the history wrong. So what do we do with that? And is that a special problem or just another of the typical stare decisis issues?
Justice Thomas's answer is that you ignore precedent and just follow original meaning. He said this on many occasions. Justice Barrett, when she was a law professor, wrote several articles saying that the court should follow the original meaning and give no weight to precedent. I think that's wrong, because I think that there are multiple sources to consider. And one of them is there is a value in following precedent. It provides stability and predictability in the law, and it should be considered along with all of the other sources. And the question is there a compelling reason for overruling precedent? But I want to just say one more thing, which also goes with what Larry said. I think what judges will often do is come to the conclusion they want and then find the historical evidence to support that conclusion. I don't think it's going to be that the Supreme Court justices are going to do the historical analysis and let them come to the conclusion. I think the same thing is going to be true with regard to stare decisis. I don't see any indication that stare decisis matters very much to the Roberts Court. I can give a long list of cases from just the last 5 years where the court has overruled precedents when it wants to overrule precedent. So I don't want to pretend that there's some neutral principle with regard to originalism or stare decisis that's being followed by the current court.
I think that's fair, but I would note it's no different for any other theory of all theories of constitutional interpretation have ways of reaching what that theory tells you is the right answer. All of them may conflict with precedent. a lot of originalism writing has been done on how to deal with precedent. So they don't all take the position that you just ignore it and just go back to the original meaning. And the way you handle it is the way any court with a theory handles precedent, which is you're balancing what are the reliance interests, how important are they, how can we chip away at it and get back at it that way, so it becomes a consideration to take into account. John McGinnis, I think, wrote an article, developing here are some simple rules to follow on when to give precedent weight and when not, and so on. So all I think I would say is different courts give different weight to precedent. Whatever your theory of interpretation is, it may conflict with the result you think is right under your theory, and it's no different for originalists than anybody else, at least as a theoretical matter.
But just speaking as a historian, don't you think the legacy of Dobbs is going to be quite interesting? I think quite profound, and it's going to leave the conservatives in an awkward position. I mean, I think we'll know more, particularly after Ohio votes. Either is that tomorrow or next week, whenever the Ohio referendum on abortion is taking place. I mean, it seems to me you just think about this not as a legal scholar, but as a political historian. The conservatives are going to be in a very interesting position when, if Alito's position is, abortion should be a matter of state decision making, and now every state that's taking it up, red states and blue states alike, are moving in one direction. The
question is whether that supports Dobbs or cuts against it. Arguably, it supports it because, this is what we said, right? And of course, it's when they move a step further and say, actually, the Constitution protects fetal life, and you can't.
Yeah.
That'll be a different kind of problem. And of course, they can't do that on originalist grounds. But
I just said in response to Judge Berzon's question, they actually have there was a Stanford journalist who's still around Palo Alto who I think just published a novel which has to do with how some document turns up and it shows that our understanding of the Constitution has been fundamentally changed. And he kind of showed this article. He said, "This is so goofy, I can't see writing a novel, on this basis." But he offered a couple other comments, but he went ahead and published it. I haven't read it yet.
All right. Huh. To me, it does feel like a different problem, where if one is regarding the history, announcing it to be conclusive, and that's another question which Jack touched on some. I mean, do historians regard history as conclusive? And let's talk about that in a minute. But if you're relying on specific precepts, I mean, not legal precepts and not economic precepts, which are, but things that purport to be facts and they turn out not to be. I.e., this historical thing actually didn't happen. Different problem than other stare decisis problems.
I don't think it would take quite that form. I think you would get, look, one of the main aims of being a good historian is to sweep your evidentiary net as broadly and widely as you can. And in fact, some documents do come into possession that do alter our understanding of some issues. I'll give one example. One of the most important members of the founding generation was John Dickinson. He's not in the Big Six, but he's the Pennsylvania farmer. He's the main author of the Articles of Confederation. He's also president of the Constitutional Convention. He has a big blow up with James Madison at one point. And Dickinson's papers only came into, from his family, were only deposited in the Historical Society of Pennsylvania sometime in the 1950s. And so they are a significant, they do provide some interesting data that wasn't available before. And they do alter, they alter our understanding in the sense of enlarging it, because now we have an additional set of sources we have to work in. I don't think you're going to find anything, Judge Berzon, maybe you're suggesting in the realm of a smoking pistol that would, lean decisively one way or the other in terms of your understanding. I think it goes back to something I tried to say earlier, that in the realm of constitutional scholarship, I think historians' obligation really is to try to reconstruct the debate, to try to demonstrate what was really at stake, and how do you differentiate Madison's position from Hamilton's, and which one seems to be more or less representative of some body of opinion, whether it's within the Constitutional Convention or the state ratification conventions, or maybe public opinion more generally. So I think, we're always looking for new sources. And when we find them, which is a great delight, it's a lot of fun. and they enlarge our understanding. Will it do so, in the smoking pistol sense? I don't think so, or at least it would be a real wonder if it did. But we would have a more sophisticated, just speaking as a story, we would have a more sophisticated understanding than the one that existed previously.
I'm going to ask one more question, and then we'll try to have a couple of questions from the audience. So legislative bodies and executive branches at the local, state, and federal level, not only or even principally courts, and this was the subject of a book that Larry KRAMER wrote, should and do consider the constitutionality of proposed actions. So how are they going to deal with the focus on history when they make decisions? Are they going to engage historians to go through historical archives before they act, i.e., if they change the restrictions on guns for domestic violence or felons or misdemeanors or so on? Will they rely on think tanks to do the work for them, many of which have ideological commitments, or will they simply enact what they think best and then pay lawyers and historians to defend their choices after historical research?
I have one thought here, which is that, again, and I'm trying to take, I'm not disagreeing with Erwin or Larry who know this, I mean, I've hung out with lawyers a lot. I'm married into a family of lawyers, but I'm just a working historian of, the 18th century. But it does seem to me that Bruin, I mean, even if you fit it into the conventional model of legal action, that Larry and Erwin have both described, it does seem to me that Bruin is adding something new to the interpretive mix if you take it seriously. And if that were the case, it has occurred to me, why would it not, it might not answer your question directly, but why not, for example, I mean, certainly wouldn't hire a think tank. I wouldn't hire the Heritage Foundation to do any historical research for me, to take one non-random example. But why not have the, what is it? Is it the Federal Judicial Center, the one that's next door to Union Station in Washington?
Right, yes.
And actually, they have promoted a number of programs just for educational purposes. I've done a couple of them in Philadelphia. In fact, one fairly recently on, on Reconstruction, the 14th Amendment and stuff like that. Why, I could imagine a coordination between that body and maybe the Organization of American Historians or the American Historical Association.
That's interesting.
And think about how would you respond professionally? I mean, I think there the obligation would be, or the opportunity would be, some issue comes up, let's assemble some pool of scholars who will try to address it. And come up with historically responsible answers. I didn't have a position on the Second Amendment.
Well, I have to come up with answers, or at least with the materials. I mean, part of the problem is just gathering the data.
Well, right. Well, historians will know to do that much better than lawyers will.
Right.
In general. I mean, not in every case, but that would be my starting position.
I want to focus on something that Jack said to answer your question. It's how Bruin is different from all other cases before it. In all other areas of constitutional law, when you're dealing with individual rights or equal protection, if there is a right that's being infringed, then the level of scrutiny is applied. And so the government can discriminate based on race if it meets strict scrutiny. The government can interfere with fundamental right if it meets strict scrutiny. Bruin expressly rejects looking at the ends and the means and says the only inquiry is a historical one of what was permitted. I don't think we should assume that the court's going to take that to other areas of constitutional law. I don't even know that the court will stick with that area and that approach to the Second Amendment. So in answer to your question, of course, all government officials take an oath to uphold the Constitution. All in deciding what to do are going to need to consider history as a factor. But I don't think we should assume that history is the only thing for these government officials to consider, or for lower court judges to consider, or that the Supreme Court just will consider in other areas.
I would agree with that. I mean, I think, again, originalism has been around for a really long time. We've been grappling with this. How do we figure it out? For Bruin, in an opinion that, and again, remember, Frank Easterbrook wrote this wonderful article back in the 80s about the court doesn't sit down and decide things as a whole. It's the accumulated effect of 9 different people. Someone gets to write the opinion. There's a huge social norm that you just go along with it unless there's something really important to disagree. And so there's tons of differences built in. So Bruin is a kind of really incoherent test that, I'm sure I actually would be really surprised if there's 5 votes to continue that even in the Second Amendment, and which is different from abandoning originalism. So there's all those aspects of Bruin that are weird. I think you can get rid of and go back to sort of the other weird kind of way we've been doing originalism. So again, if you think about how do we decide difficult economics questions in the context of antitrust law, how do we decide, it'll be the same for history, and we'll struggle along and, sort it out. I really do resist the notion that, no, there's something totally different happening here that requires a whole different kind of legal profession. We've been absorbing arguments from other disciplines since the 1920s, including history. And so, I think the challenge for lawyers remains the same when you're advocating in a case, and the courts are going to have to sort this out as they go along.
So, Robin, do you have any questions from the audience that we should consider?
Yes, and I'm going to just be the disembodied voice here, reading them to you, so you can still be the focus. Following up, I think, on that last point, one of the questions is, shouldn't historical evidence then require a testifying expert subject to cross-examination?
Erwin, why don't you? I'm talking too much.
I think there's a really important question. Are we talking about a matter of fact or a matter of law when we're discussing this? So with regard to the Second Amendment, is to Rahimi a question of fact that we have to determine as to what was the practice in 1791? If so, then I would say, yeah, it should be treated like any other matter of fact and experts. Or is it ultimately a conclusion of law that the court comes to as to the meaning of the Second Amendment, just like it's a conclusion of law, like to the meaning of a statute or the meaning of any other constitutional provision? I would lean towards thinking it is always as a question of law that may be informed by expert testimony or be informed by research, but I don't think it's a question of fact.
I had a strange experience. I talked about at the very beginning, back in the mid 1983, so 40 years ago, with the Oneida Indian litigation. The key issue was the meaning of a clause in Article 9. I think it's Clause 4 of the Articles of Confederation. It says Congress will have the sole exclusive right and power to regulate the trade and manage all affairs with Indians, not members of any of the states, provided that the legislative right of any state within its own limits be not infringed.
Or not only interpreting the Constitution, now we're interpreting the Articles of Confederation.
There is no law in the Articles of Confederation. So this was a 12b6 motion to dismiss for failure to state a claim. And the curious thing about this is there is no law in the Articles of Confederation. It's only in operation for 8 years and a variety of things. But there actually were panels of scholars who were convened to work this out, and there was crossing. Well, it didn't work by cross examination. No, I think, but there was some oral argument, and we did meet in federal district court in Syracuse for a couple days, and then some years later we actually had a dinner at Boston College Law School, so my wife's alma mater, by the way. And the federal judge who heard the case said he knew what he was going to do all along. The Second Circuit had ordered him to have an evidentiary hearing. Wasn't going to change his opinion. He knew what the outcome was going to be, but he had to go through the motions. So we did it quite seriously, and I learned a lot about historical arguments.
So he did have an evidentiary hearing, or he has?
No, we had one. I don't think it affected the judge. He knew what he wanted to do anyhow. Second Circuit said you got to do it, so he did it.
I'm with Erwin. It's a question of law. The judge has latitude to decide how to get the information he or she wants for it. But for instance, you're not going to submit this to the jury, right? So it's the judge interpreting the Constitution and going to drag in, bring in whatever information, whether it's through briefs or through witnesses that the judge feels they need in order to make that decision properly.
Okay, Robin, another one?
Yes, Judge Bork might have said that if the founders didn't intend to practice today because there was no analogy for that practice in 1789 or 1868, then the Constitution simply does not speak to it. Amend the Constitution if you can, but you cannot change its original intentions. What is the appropriate response to that, quote, change the Constitution, don't reinterpret it, end quote, argument?
I'll go back to the examples I started with. Let's take Brown versus Board of Education and Loving versus Virginia, because I don't think either of those could be justified from an originalist perspective. Then the answer would be from an originalist, we'll amend the Constitution in order to end segregation, or amend the Constitution or to end laws that prohibit interracial marriage. To me, that doesn't make sense, because we can't say the only way we're going to protect a minority is for a supermajority to act. And again, I think that we could say that the purpose of equal protection is served by Brown versus Board of Education, is served by Loving versus Virginia, and that's sufficient. But I think under the Bork theory, you need a constitutional amendment, and that shouldn't be in order to achieve these essential results for society.
And this is why Bork didn't get approved by the Supreme Court, and why Scalia called himself a faint-hearted originalist. He wasn't willing to go that far, because there is a point at which you're still deciding cases for a real society with real people.
I'll make one passing historical point very briefly. You know, our common assumption is Article 5 is so, you know, the amendment procedures are so difficult that in effect the whole option of amendment is so impractical that we can't really use it. I'll just say from the 1787 perspective, the framers thought they were actually improving the situation. Under the Articles of Confederation, there was only one way to amend the Constitution. You had, the Continental Congress had it proposed by, I think, a 9-vote, nine states out of 13, and you had to have unanimous, consent for the state legislatures. Under Article 5, there are two ways to propose, and there are two ways to amend, and you don't have a unanimity rule. So they actually felt that they were kind of opening the system up. It's the bitter lesson of experience that it just doesn't, it's very hard to work. Although
a really good example of why originalism is a really terrible way to interpret the Constitution. I mean, they also only had 13 states,
Erwin
and they
and I
also
were
didn't
at
have
a
slavery.
fascinating lecture last week about the proposition of amendments, and partly about the convention method of interpretation, which it turns out is generating its own vehement debate about what in fact was, how in fact one would implement that, and how you would find out how you would implement it, i.e. who are the delegates to these conventions and how do they operate. And apparently there are propositions being put out by the Koch brothers and others about how this would operate. So we're back, I guess, into another debate about what was intended, or how you figure out how to proceed, if anybody ever actually tried to go that route. Any other comments on this question? No? Okay. Robin, anything else?
Next question. Is the First Amendment a history-free zone, since nearly every justice views the First Amendment as more speech-protecting than the founding generation did?
Well, there are famous arguments about early First Amendment law. Leonard Levy, who was an extremely distinguished constitutional historian, got in some trouble over this. I think with Justice Black got very upset with his work that that there was a limited understanding of the First Amendment in the 1790s, essentially no prior restraint, but you could still be prosecuted for seditious libel. But that came under a lot of stress in during the period of the Alien Sedition Act, 1798, 1799, 1800. 1801. So there is a lot of historical work on the original understanding of what the First Amendment meant.
And what about the question? It's always interested me is what light does the Alien Sedition Act throw on that? The fact that the same people, or some of the same people, enacted the Alien Sedition Act, because that's the kind of arguments that are being made now. That is, the people who wrote and ratified the Constitution then passed X and Y and Z in statutes, and so that's supposed to demonstrate what they were thinking of.
Right. Well, there's a lot of criticism of Levy's work, and you wound up having to do a second edition, or you would not a massive revision, but that there were in fact a lot of more libertarian arguments flourishing in the late 1790s, saying we should reject this British model of sedition because it's not appropriate for a republican form of government, It may have been something that John Adams liked, but it had a lot of critics. And so so again, this goes back to something I tried to say earlier, that there was a much more active debate about it, that historians go out and they find other sources, or it's the way our profession works, not necessarily by cases.
I do think you want to distinguish between the theory and the way it's applied. So yes, the First Amendment and the jurisprudence of the court is kind of a history-free note. They don't use it there because it doesn't get them the results they want. Same thing with the affirmative action cases. There is no perspective from which you can reach the result they reach. And they didn't even, Thomas tries in a really embarrassing opinion. The majority opinion doesn't even try to make a historical argument. Dobbs, the histories, so that those are two different things. But it's also, again, not particularly unique. I think judges, like all people, sort of operate with a hierarchy of commitments. And some of their commitments are jurisprudential and some of them are substantive. And whenever a higher commitment comes in conflict with a lower commitment, the higher commitment wins. Justice Brennan had a jurisprudence. It was just pretty low in his hierarchy of values. He had substantive commitments and he went with those. So he's not necessarily theoretically. Scalia gave a much higher weight to his jurisprudential commitments, but he also had substantive commitments he cared about more, like the idea of colorblindness and affirmative action and so on. So it's not unexpected to find that kind of inconsistency. You don't find consistency anywhere. And as I say, it's just a different question. So, you can't justify their first, they don't even try. It's a very much libertarian mid-20th century view of speech that they now apply aggressively in activist forms.
Not all conservatives regard the First Amendment as a history-free zone. Just a year ago, a judge in the Fifth Circuit said the First Amendment should be understood only as preventing prior restraints. This was in the case now before the court, Net Choice versus Paxton. And it was stunning to see a judge now taking a theory that the Supreme Court has rejected for a century. And it'll be interesting to see when it comes before the Supreme Court this spring. Will the originalist justices say the First Amendment is limited to just prior restraints, which seems an absurd position? I think that with regard to the First Amendment, it's so hard when you talk about all of the media that's developed, starting with movies and everything through the internet and social media, to try to think about how does the First Amendment, as the framers understood it, apply to that. There weren't analogous media at that time.
Well, we're almost at the end. The example I always give about the difference between what people believe and how they apply it has to do with my advent as a Supreme Court justice. And Justice Brennan had written the Frontiero opinion, which was very eloquent about why sex discrimination should be covered by strict scrutiny, and why to do otherwise was to put women in cages rather than on a pedestal. And the year after that, he originally flatly refused to hire me because I was a woman, until one of his former clerks went to him and said, "Justice Brennan, this is not consistent with your principles." And he said, "You're right." And this was Steve Barnett, and you must be a very good lawyer, and you're right. And he hired me. But sometimes people just don't get the connection between their highest expression of their aspirations and their principles and the way they live their lives on a daily basis. And I think that's true with regard to how legislators or executive branch people operate, despite their belief in abstract principles, which they have, and then they go about their lives and about their legislating and so on. So with that personal story, I want to thank this amazing panel for an incredibly invigorating discussion, and which I hope we get to do again with another group of people sometime. And really, again, it was unfortunate that we didn't get to be in the same room at the same time. It's always better, but I guess this is the times we live in. So thank you all enormously. It was really wonderful to listen to and to participate in. Robin.
And I just wanted to also thank all of you, the panel, for all of the time and effort you've put into this program, and for Judge BERZON for her leadership in creating this panel and putting it all together. And to thank all of those people who are on the Zoom with us tonight. I really appreciate you being here. And one further word of thanks also before you go to the IT staff of the court, Sam Gerard in particular, and to Audrey Barrett of the NJCHS, who makes all of this happen seamlessly. We hope that you'll all join us at another program. And again, please go to njchs.org and get on our mailing list and maybe become a member, support more programs like this. Thank you all so much for being here. And thanks again once to our panel. You are all amazing.